The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 837, coming to you on Monday the 12th of September 2016. On this program, I will speak to you on the topic, Justice Delayed is Justice Denied. But before getting into the topic, a few preliminary comments. Firstly, and as usual, I would like to send out deepest condolences to all families which have suffered recent bereavements. Secondly, as you would be aware, those who looked at the program last week, Monday, I spoke on the topic of financial obligations in the context of children going back to school and not being properly maintained by fathers, particularly where fathers face court orders for the payment of maintenance. Well, within 10 minutes of the end of the program on Monday night, I received a telephone call from a good friend and brother of mine. He said, "Mr. Campbell, when are you bringing over the next part?" So I said, "What part?" He said, "The part about the woman. You have to speak about the women who get maintenance money and spend it on themselves, putting in weaves in the hair, putting on artificial fingernails, and having nice time." So I promised my good friend and brother Leo that on this program I would say a word about delinquent mothers. Yes, there are some women, hopefully very, very few in number, but some women are even worse than the men, because it is bad enough for men not to pay maintenance. It is worse if they pay the maintenance money and instead of spending it on the children for whom it is designed, for the mothers of these children to go and lavish the money on themselves. And as my brother Leo put it, putting in weaves and artificial fingernails and having a nice time. So those women who indulge in that practice are even worse than the delinquent fathers. Shame on you, women. But I dare say that those numbers would be few and far between, but they do exist, and I must acknowledge that. So thank you, Brother Leo. Now the topic for this evening, Justice Delayed is Justice Denied, was prompted by a story I saw in one of the weekend newspapers last week, Friday, about certain persons being on remand for more than 9 months. Remand means that a person is charged with an offense or offenses. The person is either denied bail or has been admitted to bail, but nobody could be found to stand surety for him. And the person is actually in prison awaiting trial for the offense or offenses. What does our Constitution have in mind? Well, Section 8 of our Constitution, which is headed Provisions to Secure the Protection of Law, Section 8.1 says this: if any person is charged with a criminal offense, then, unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time by an independent and impartial court established by law. The Constitution goes on to state in subsection 2 of section 8, paragraph A, every person who is charged with a criminal offense, A, shall be presumed to be innocent until he is proved or has pleaded guilty. And then it goes on A, B, C, D, E, F. So the presumption of innocence continues to apply to anyone who is charged until that person has been found guilty or until that person has pleaded guilty if the case is not withdrawn. So that when somebody is on remand for months, in the case I read 9 months, it means that person's case has not yet been heard, but the person is in jail, albeit not as a convicted prisoner, but as a remand prisoner. Now, being in jail is being in jail. Whether you are a convicted prisoner or somebody on remand, it simply means you are locked up. You have been denied your freedom. You are put under certain restraints. Albeit that as a remand prisoner, you are permitted to wear your own clothes. I don't know if that has changed, but in the days when I was in charge of the prisons as Minister of Justice, remand prisoners were allowed to dress in their own clothes. You only had to put on the jail uniform when you were convicted. But there surely must be something wrong with a person languishing in prison, presumed by the Constitution to be innocent, and has to wait a long period of time, through no fault of his own, before that case can be brought to the court for trial. Justice delayed is justice denied. What does the Constitution mean by a reasonable time? Unfortunately, in my respectful opinion, the courts have been extraordinarily lenient on prosecuting authorities by the flexibility they have shown in the application of the phrase reasonable time. When I was Attorney General and Minister of Justice in the early 90s, I was invited by the United States Embassy in Barbados to go on what they called the International Visitors Program, IVP, where in collaboration with the embassy officials, I indicated the institutions I would like to visit in the United States, and an itinerary was arranged, all at the expense of the American government. I was able to look at facilities, justice facilities in Washington, New Orleans, Los Angeles, Nebraska, and back to Washington. And one of the things that struck me about the American system is in the federal justice system, there was a law that anyone who was charged with an offense had to be tried within 3 months. The case had to begin in 3 months' time of the date when somebody was charged. because in their system they regarded it as unduly long if somebody is locked up for more than 3 months awaiting the trial of the case with which they have been charged. And they felt 3 months is the upper limit. Well, our courts in the Eastern Caribbean have been much more relaxed, and long periods of incarceration on remand have been regarded by the court as not being unduly long. To me, 9 months is unduly long. In fact, anything more than 6 months, in my respectful opinion, is being unduly long. There are cases where you would read in the newspaper that somebody has been charged and the prosecution tell the magistrate they are not ready to proceed. Well, if you're not ready to proceed, why charge? And when you charge, you should make sure you marshal your evidence and your witnesses so that a person whom the Constitution presumes to be innocent isn't made to remain in prison month after month awaiting trial. Now, let me say this. I understand the difficulties facing the prosecuting authorities. I understand the pressures under which the police operate. I understand the system. But what I also understand is that there is no sense of urgency in bringing matters to trial. Occasionally, the officer investigating an offense goes on leave or is attending a seminar or a workshop or some other training exercise. And usually when an officer is investigating a matter and is not available, no one carries on the investigation in his place because the other officers are busy with their own investigations. And we all have seen the results of that. How many times we don't read in the newspaper that so-and-so has been acquitted, not because basically the person didn't commit the offense, but because the prosecution has slipped up. A vital witness is absent and nobody kept track of the witness to know that they had traveled. Or for some other reason, the case is not perfected. And there is one extremely brave and able prosecutor who interprets the prosecutorial guidelines, in my view, quite correctly and regularly discontinues prosecuting cases where, in his view, there is a lapse by the police in the investigation. I am sure that there are many who disagree with the standards he has taken. But that prosecutor is quite correct in my view, because justice is a serious business. And when the state deprives anyone of his or her liberty by way of arrest and charge, the state should see to it that the procedures are followed through expeditiously, that the case is brought to trial in as quick a manner as is humanly possible, and that all the evidence is properly deployed. It is demoralizing for the victim of a crime to go into court for the case, and here the case is thrown out because of some lapse by those whose duty it is to present the case in a proper manner. So the longer that a person is waiting his or her trial, the greater the chances that when the trial takes place, the person would be acquitted, because prosecution witnesses over time have lapses of their recollection. They can't quite remember what happened, and in cross-examining them, defense counsel is able to exploit imperfections in their memory. Exhibits get lost or misplaced. And the virtual complainant, who has been the victim of the crime, has to hear the judge or magistrate say to the accused person, "You are free to go. There is no case to answer." All of these things could be reduced if a greater sense of urgency is used by those whose duty it is to prepare and present cases against accused persons. In the first place, the very guidelines which have been publicized by the DPP's office indicate that charges should not be laid until there is a certain minimum level of evidence necessary to convict the person on the charges as laid. So that the authorities shouldn't rush to prosecute until they know they have a good case and they have their evidence. And if you have a good case and you have your evidence, why is it taking months and months to bring the case to trial? What makes the situation so grievous is that in our system, there is no compensation payable to somebody who is on remand for an inordinately long period of time and who is eventually acquitted. The authorities don't have to pay you for the time you lost sitting in jail waiting for your case to be heard. Months of your life would have gone by, and if you are acquitted, that's simply too bad. There's no compensation. You can't sue the government unless you can prove malicious prosecution, and that is normally difficult. If you can prove that the prosecution didn't have any probable cause at all to charge you, and that somebody charged you deliberately and maliciously, knowing that the evidence was not there to secure a conviction, in that case you might be able to sue the Crown for malicious prosecution, but it is not easy to sustain a suit of malicious prosecution against the Crown. Once they could show that there is some probable cause, and once they can dispel the allegation that somebody was malicious in charging the accused person. Excuse me. So that the freedom of the individual must not be taken for granted. The authorities cannot say, oh, this person is a habitual offender, and therefore we know he is going to be found guilty of this offense, and let him wait. Let him languish in prison. Remember, I am speaking of cases where bail would have been refused. There's the odd case where bail is set and the person simply can't come up with sureties. But even so, the person shouldn't be made to await more than a reasonable time, according to the Constitution, for his trial. I'm speaking about cases where the prosecution opposed the granting of bail, particularly in the case of people who are not from here. They don't belong to St. Vincent, so okay, you say they have a more than reasonable chance of flight. If they get bail, they would run away. They would slip away from St. Vincent and Grenadines. So their travel documents are taken from them, they are denied bail, and what? They're just kept locked up month after month, no trial. That is not in keeping with what the Constitution says. And let me remind you of what it says. Section 8, subsection 1. If any person is charged with a criminal offense, then unless the charge is withdrawn, the case shall be afforded a fair hearing within a reasonable time. How could 9 months be reasonable for somebody waiting to have a case heard? Presumably when the prosecution thought they had enough evidence to try them in the first place and then lay charges against them. We cannot take these things for granted and feel, oh, well, everybody is busy, we have a lot of things to do, let them wait in jail. No, that's not what the Constitution says. That's not in keeping with the rule of law. The rule of law requires us to respect the rights and freedoms of individuals, even though they are persons with previous criminal convictions. The fact that the person has been convicted of an offense before doesn't necessarily mean they're guilty of the offense with which they have been charged. Each incident has to be looked at with fresh eyes. Indeed, during a trial before judge and jury, it is only in rare cases that the prosecution is permitted to tell the jury that this person has been convicted of previous offenses. The circumstances are narrowly circumscribed, so that theoretically the jury assesses the evidence without knowing anything about the antecedents of the person whose case is before them. They are supposed to look purely at the evidence led in that specific case and determine innocence or guilt on the basis of the evidence led before them, not on the basis of what they have read in newspapers or seen on the internet or heard. They are to assess the evidence as presented to them. They are to know that the person before them starts off as being innocent in the eyes of the law and in the eyes of the Constitution, and that the person remains innocent until they, the jury, bring the person guilty, or until the person changes his or her plea from not guilty to guilty. Now, some people feel that the law is funny, that the law is ridiculous, that the law is on the side of the criminals. Well, there are cases when it is reasonable to harbor those feelings towards the law. The law is not perfect, and things do go wrong. Yes, innocent people do get convicted, and guilty people do get off. That happens because the human institution that is the law and criminal procedure is not perfect. Allowances have to be made for human error. But it is difficult to make allowances for human negligence when cases are not brought before the court in due time, and where the persons whose cases are to be heard night after night are in confinement in prison, pondering their fate. And many of them ultimately to be told, well, you are acquitted, you're free to go, having wasted months of their lives in confinement just because somebody didn't do his or her job properly or adequately. So I'm appealing to the prosecuting authorities, the police, and the members of the staff of the DPP's office, that they should take more seriously the situation where people are on remand, in prison, awaiting trial. If you don't have the evidence to try the people, let them go. If you have the evidence, bring it on. It is not good at all to have people languishing in a situation where the Constitution deems them to be innocent. And the longer that people are awaiting trial, the greater the chances, as I said before, that when the case is heard, they will be acquitted. Because the quality of the evidence would deteriorate over time in terms of the recollection of witnesses and even the testimony of experts. I do hope that the authorities don't feel that I have been too critical, but somebody has to speak up about these things, particularly when we're dealing with people who are not from here. The fact that they're not been sentenced doesn't give us any excuse, any justification for keeping them in prison month after month after month and wouldn't bring the case on for trial. That is simply not good enough. That is all from this program of The Law and You. I look forward to being of further service to you next week, Monday DV, for another presentation in this public service nation-building series, The Law and You. Do have a very pleasant week, ladies and gentlemen, brothers and sisters, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.